Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce. Hello, and thank you so much for joining us for another session of Day with DISA. Today, we've got a background screening session focused on navigating ban the box and fair hiring laws specifically for private companies. Today, we're joined by Eden Hutchinson, the Compliance Investigation Manager for DISA Global Solutions. Eden, how are you doing today?
Hey, Thomas, I'm great. How are you?
I'm doing pretty good, and I'm excited to get into this presentation. But before we do, I want to remind everyone that if they have any questions, they should use the Q&A button at the bottom right of the player. And if we're unable to answer your question today, we'll reach back out to you at the end of Day with DISA and get those questions answered for you. Additionally, we're going to make a copy of this presentation available for download on the Materials tab at the end of the session. With that being said, Eden, the floor is yours.
All right. Thank you, Thomas. Yes, as Thomas mentioned, my name is Eden. I'm the Compliance Investigation Manager here at DISA Global Solutions. I'm really excited for Day with DISA. And this year, I'm going to be covering navigating ban the box and fair hiring laws for private employers. So first off, I want to start off by saying the information in this session is for educational purposes only. DISA recommends all of our clients consult with their legal counsel on all employment screening matters, just to make sure that you're compliant with everything that's applicable. So first, I want to jump in to an overview of what ban the box is, as well as some history behind this phenomenon that I'm sure you guys have heard about at one point or another. But ban the box laws, which are sometimes referred to as fair chance, fair hiring, or equal employment laws, are laws that dictate how employers are allowed to request, use, and consider criminal records in employment decisions. It used to be pretty common practice for employment applications to have that little box on them that asked the applicants whether they had any criminal history. And the answer to that question would often determine whether the applicant would be considered any further. So that box is the box that ban the box refers to. So according to a policy brief released by the National Employment Law Project in April 2023, or NELP, over 70 million people, or nearly 1 in 3 U.S. adults, have some kind of criminal record that could potentially show up on a background check. Excluding these individuals from employment is shown to contribute to a lack of racial diversity and occupational segregation in the economy. So ban the box laws were really created to allow these individuals with criminal history a fair chance of finding employment. These laws also help employers avoid intentional or unintentional discrimination, including disparate impact discrimination. And they really do help employers identify appropriate and qualified individuals for the job. If an applicant is denied simply because of a past criminal record, you may be missing out on a great employee who is the perfect fit for the job and a great asset to your organization. So ban the box laws can dictate or prohibit different things, but generally we see them do the following. These laws may dictate what questions employers can ask their applicants or employees at different times in the employment process. These laws may determine when an employer can inquire into an applicant's criminal history, such as not being able to ask until after the first interview, or in many cases, you'll see not until after a conditional offer of employment is made. Employers may not be able to request or consider certain types of criminal records, including requests made to consumer reporting agencies like DISA. Some laws have adverse action requirements as well, such as requiring that certain documents be provided to the applicant or employee during the adverse action process. these laws may require that employers perform individualized assessments to carefully consider a lot of different things about the criminal offense, like how it relates to the job, the time that's passed, and so forth. The laws may also dictate how long employers must wait between the pre and final adverse action stages. So ban the box laws can be at the federal level, they could be at the state level, or even the city or county level. Some states may even have one ban the box law, while a city or county within that state has an entirely different law. So it's really important to keep that in mind when trying to figure out which laws apply. Speaking of application, these laws can apply to the location of the employer, or they could apply to the city or state that the applicant or employee lives in. Many employers choose to apply both just to be safe and make sure that all their bases are covered. These laws can apply to private employers, public employers, or both, but today we're just going to be talking about those laws that apply to private employers. So the first US state to implement a ban the box law was Hawaii in 1998. Other jurisdictions started to follow after that, and now we currently have 18 states and about 21 cities and counties that have also jumped on that bandwagon and implemented ban the box laws for private employers. So we're going to go over our current list of ban the box laws for private employers within the US. But I do want to point out, though, that for each of these laws, there may be exceptions. So exceptions for employers in certain industries or even for certain types of positions. So again, be sure to check with your legal counsel. So as you can see by the graphic here, some states have just a state law, some have no state law, but a city-county law, and some have both. So we're going to start off first with California, and not only because it's the first alphabetically on our list, but because California is everybody's favorite state in regard to employment screening laws. It's true. California Assembly Bill 1008, in conjunction with a recent Fair Chance Act amendment, applies to employers with 5 or more employees. Employers are not allowed to include any question on an application or otherwise inquire about an applicant's conviction history before they make a conditional offer of employment. Employers are not allowed to consider arrest records that did not result in a conviction unless the case is currently pending. Convictions that have been dismissed, sealed, expunged, or statutorily eradicated under the law, juvenile records, or any non-felony convictions for possession of marijuana that are more than 2 years old. Employers must also make an individualized assessment of whether the conviction history has a direct and adverse relationship with the job. They must send pre-adverse action notices to the applicant or employee. That includes a notice of the disqualifying convictions that are a basis for the preliminary decision, and a notice that their right to respond, notice of the right to respond before the decision becomes final, as well as an explanation informing them that they may dispute the accuracy of the information or provide evidence of rehabilitation or mitigating circumstances. Now, employers must wait 5 business days from the receipt of the notice before they make that final decision. So the date of receipt is calculated based on a couple different things. So for example, if the preliminary notice is sent via untracked US mail, it's going to be considered received 5 calendar days after mailing to a California address, 10 calendar days after mailing to an address in any other US state, and 20 calendar days after mailing to a non-US address. If the applicant notifies the employer in writing in a timely manner that they're disputing the accuracy of the information and are taking steps to get evidence to support that dispute, then the employer is required to wait an additional 5 business days before making a decision. And aside from California state law, Los Angeles and San Francisco both have their own ban the box laws. Los Angeles ordinance applies to Los Angeles employers with 10 or more employees, prohibits employers from inquiring into criminal history until after making a conditional offer of employment, and requires that employers make an individualized assessment following the Equal Employment Opportunity Commission, or EEOC's green factors. They must provide their applicants and employees a copy of the LA Fair Chance process, and they have to wait 5 business days before making a final decision. San Francisco's ban the box law applies to employers with 5 or more employees. And while there's no waiting period requirements, it has very similar requirements to the state law. So Colorado HB 19-1025 applies to all private employers regardless of size. This law prohibits employers from stating in an advertisement or on an application that anybody with criminal history shouldn't apply. The law also prohibits employers from inquiring about or requiring their applicants to disclose criminal history on an initial application, but it does allow them to obtain a publicly available criminal background report at any time during the process. Connecticut's law applies to employers with one or more employees and states that employers may not inquire into an applicant's prior arrests, criminal charges, or convictions on an initial employment application. They also may not deny employment, terminate, or discriminate against a current employee for any erased or pardoned criminal records. The District of Columbia's Fair Criminal Record Screening Act of 2014 applies to any person, company, corporation, firm, labor organization, or association with more than 10 employees in the district. Employers are not allowed to make an inquiry about or require a disclosure into an applicant's criminal conviction history until after a conditional offer of employment is made. And then after that, they can only withdraw the conditional offer or take adverse action against an applicant for a legitimate business reason based on certain criteria. If requested by the applicant, the employer must provide within 30 days copies of all records obtained and used by them in their hiring decision, as well as a notice that advises the applicant of their opportunity to file a complaint with the Office of Human Rights. Now, Florida has no state ban-the-box law, but the city of Gainesville did recently pass an ordinance in January of 2023 that applies to any person, company, corporation, firm, labor organization, or association with 15 or more employees who primarily work in the city. Employers are not allowed to publish information about a job that states or implies that an individual's criminal history automatically disqualifies them. And they may not inquire about the criminal history of an applicant until a conditional offer of employment has been made. Employers are also not allowed to refuse to consider an applicant if they failed to provide criminal history information prior to getting that conditional offer of employment. Employers may not take adverse action against an applicant based on their criminal history unless they determine that the individual is unsuitable for the job based on an individualized assessment. Now, before the employer can take adverse action here in the city of Gainesville, they are required to inform the individual of the basis for the decision. If a final decision is made based on criminal history, then the employer needs to tell them that it was based on criminal history. And they have to include a statement in the final adverse action notice that states that this notice provided is done so in accordance with City of Gainesville Code of Ordinances. So we already touched on Hawaii briefly, but Hawaii's ban-the-box law is short and sweet. It prohibits employers from inquiring about and considering conviction records for employment purposes until after a conditional offer of employment is made. Employers may also only consider an individual's conviction history for employment purposes if the conviction record bears a rational relationship to the duties and responsibilities of the position. Okay. The State of Illinois' Human Rights Act applies to any person or private entity that has 15 or more employees. Employers and employment agencies may not inquire about, consider, or require disclosure of the criminal history of an applicant until they've been determined qualified for the position and notified that they've been selected for an interview. If there's no interview, then the employer has to wait until after that conditional offer of employment is made. Employers may not consider conviction records for employment purposes unless there's a substantial relationship between the criminal offenses and the employment, or unless allowing the individual employment would involve an unreasonable risk to property or to the safety or welfare of specific individuals or the general public. Employers have to perform an individualized assessment, and when they send the pre-adverse action notice, it has to include notice of the disqualifying convictions that are the basis for the preliminary decision and the employer's reasoning for the disqualification. And then finally, they must include an explanation that the employee has a right to respond, dispute the information, and provide evidence of mitigating circumstances. Now, Illinois has a 5 business day waiting period between the pre and final adverse action notice. And with the final adverse action notice, they must also send any existing procedure they have for the employee to challenge the decision or request reconsideration and the right to file a charge with the department. Now, Chicago's municipal ordinance, which applies to any employer with 1 or more employees, is very similar to that of the state of Illinois. They must consider the same individualized assessment questions. They have the same adverse action letter requirements, and they also have a 5-day waiting period. The big difference there, though, is the section in what circumstances they're allowed to use conviction history. Chicago's does provide a little bit more information than the state. So Iowa is another state that has no ban-the-box law, but the city of Waterloo does. This law applies to any person, partnership, company, corporation, labor organization, or association which regularly employs 15 or more persons within the city. Employers may not inquire about or require disclosure of any convictions, arrests, or pending criminal charges during the application process, including the interview, until they've made a conditional offer of employment. In addition, employers are not allowed to take adverse action based on an applicant's criminal record history without a legitimate business reason. Maine's HB 845, which applies to all employers and anyone acting in their interest, directly or indirectly, prohibits employers from requesting criminal history record information on the initial application. Employers may not state on that application or in any advertisement or specify prior to determining a person is otherwise qualified that a person with a criminal history may not apply or will not be considered. Maryland, along with several jurisdictions within the state, also have ban-the-box laws. The state's law, which applies to all employers with 15 or more full-time employees, states that employers may not require an applicant to disclose whether they've had a criminal record or have had criminal accusations brought against them before the first in-person interview. Baltimore says that employers with 10 or more full-time employees may not inquire into or require the applicant to disclose or reveal that they have a criminal history or even conduct a criminal record check until after they make a conditional offer of employment. Montgomery County has the same prohibition, but instead it applies to employers with 1 or more persons within the county. The same goes for employers in Prince George's County with 25 or more full-time employees. This county, though, has a few additional requirements. Employers must conduct an individualized assessment, considering only specific offenses that may demonstrate unfitness to perform the duties of the job, the time that has passed since the offense took place, and any evidence of inaccuracy in the record. Employers must also wait 7 days before making the final determination to allow the applicant time to file that dispute. Massachusetts has a couple different applicable laws, but they don't clearly identify any specific accountability. Bill S 2371 prohibits employers from inquiring into convictions for misdemeanors that are more than 3 years old, as well as sealed or expunged records. Any application for employment that asks for information regarding prior arrests or convictions is required to have a specific disclaimer included that tells the applicant when they're allowed to claim that they have no records. Chapter 151B, Section 4 of the General Laws of Massachusetts prohibits employers from requesting non-conviction or sealed or expunged records. This law also has limitations on the types of misdemeanors that can be inquired into, such as first convictions for drunkenness, simple assault, speeding, minor traffic violations, and so on. Minnesota is another short and sweet ban-the-box state, prohibits all employers, including Minnesota operations of companies that operate in multiple states, from inquiring into, considering, or requiring disclosure of an applicant's criminal history for employment purposes until the applicant has been selected for an interview. If there's no interview, then they have to wait until after a conditional offer of employment is made. So within Missouri, Columbia, Kansas City, and St. Louis all have citywide ban-the-box laws. Applying to employers with 1 individual, 6 or more employees, and 10 or more employees, respectively, each city requires that employers make an individualized assessment and consider all information available to them when making their employment decision. In addition, St. Louis does not allow employers to publish job advertisements or employment applications which exclude applicants on the basis of criminal history, inquire into, or require applicants to disclose their criminal history in the initial phase of the hiring process, or to seek to obtain publicly available information concerning job applicants' criminal history. New Jersey's Opportunity to Compete Act applies to any person, company, corporation, firm, labor organization, or association which has 15 or more employees over 20 calendar weeks and does business, employs persons, or takes applications for employment within the state of New Jersey. You'll see the applicability for all of these states. Some are a lot more detailed than others. Employers may not inquire into or require that an applicant complete an application for employment that makes any inquiries into their criminal record during the initial employment application process, and they may not publish any job advertisements that state that the employer will not consider applicants that have been arrested or convicted of 1 or more offenses. Employers also may not refuse to hire an applicant based on records that have been expunged or erased through executive pardon. New Mexico's law simply states that employers may not inquire into an applicant's history of arrest or conviction on the employment application, but they're allowed to do so after review of the application and upon discussion of employment with the applicant. Okay, New York, another fun one that we're going to spend a little bit of extra time on. The state of New York itself has New York Article 23A, which applies to any person, company, corporation, labor organization, or association which employs 10 or more persons. Article 23A mainly focuses on individualized assessment and has some pretty detailed requirements. Employers are not allowed to deny an individual employment or take adverse actions simply because that person has previous convictions or because they have found them to lack good moral character due to those convictions, unless there's a direct relationship between 1 or more of the previous criminal offenses and the employment, or the granting or continuation of the employment would involve an unreasonable risk to property or to the safety or welfare of specific individuals or the general public. Before taking adverse action, the employer must consider multiple things, such as the specific duties of the job in question, the bearing the offense has on the job, the time that's passed since the offense, the age of the person at the time of the offense, and so on. Employers must consider any certificates of relief from disabilities or certificates of good conduct that are issued to the applicant as well. And then finally, if requested by the applicant, the employer needs to provide a written statement setting forth a reason for the denial within 30 days. In addition to the state's Article 23A, which applies to all locations within New York, Buffalo, New York City, Rochester, Suffolk County, and Westchester County all have local ban-the-box laws as well. We are going to save New York City for last because it is the most involved. Buffalo's Ordinance 0096 applies to employers with 15 or more employees located in Buffalo city limits. Employers may not inquire into, consider, or require disclosure of a candidate's prior criminal conviction history until after an application is submitted and then during an initial interview. The Rochester ban-the-box law applies to employers with 4 or more people in their employ. Employers may not inquire into or require disclosure of any criminal convictions during the application process until after the employer has conducted an initial interview and made a conditional offer of employment. Employers are prohibited from asking at any time for applicants to disclose information about certain juvenile arrests and sealed records as well in Rochester. Now, Suffolk County's laws apply to any person, partnership, corporation, labor organization, not-for-profit, or association in the county with 15 or more employees. Employers may not inquire into or require disclosure of a person's criminal conviction history until after the first interview. If the employer does not conduct an interview, they must inform the applicant whether a criminal background check will be conducted before employment is to begin. Westchester County's local law applies to any person with at least 4 persons in their employ. Employers may not make preliminary or initial inquiry or statement related to a criminal conviction or arrest record in an application for employment. They also cannot declare, print, circulate any solicitation, advertisement, or publication which expresses directly or indirectly any limitation or specification in employment based on a person's arrest record or criminal convictions. Inquiries into an applicant's arrest or conviction history may be made after an application for employment is submitted. Okay, so now New York City. New York City's fair chance law prohibits employers from inquiring about or making any statement related to the pending arrest or criminal accusation or criminal conviction record of an applicant until after a conditional offer of employment is made. Now, in this law, a conditional offer of employment means something a little different than what we're used to seeing. Guidance interprets this to mean that the applicant has otherwise been deemed qualified of the position or for the position, and only then is a conditional offer extended. In this law, that conditional offer may only be revoked based on the results of a criminal background check, the results of a medical exam, or any other information the employer could not have possibly known before making the conditional offer if the employer can show that they have an affirmative defense that, based on the information, it would not have made the offer regardless of the results of the criminal background check. So in short, non-criminal history background checks, such as education and employment verifications, should be completed and cleared before criminal history, including motor vehicle reports, may be requested or considered. This may mean that employers are going to need to have 2 separate background checks or have an internal process to separate the review of the non-criminal and criminal aspects of the consumer report. Employers may not take adverse action against an applicant or an employee just because they've been convicted of 1 or more criminal offenses or by reason of finding the person lacks good moral character based on those convictions, unless they first consider relevant fair chance factors. Before taking any adverse action based on the applicant's arrest or conviction record, employers in New York City must provide a written copy of the inquiry to the applicant or employee, request from the applicant or employee information relating to the relevant fair chance factors, and perform an analysis and provide a copy of that analysis to the applicant or employee, which must include supporting documents that form the basis for an adverse action based on such analysis and the employer's reasons for taking any adverse action against the applicant or employee. The employer must allow the applicant no less than 5 business days to respond, and they have to hold that position open for the applicant during that time period as well. So Oregon's ban the box law states that employers may not exclude applicants from an initial interview just because of past criminal conviction. If there is no interview, employers may not require that the applicant disclose criminal convictions until after a conditional offer of employment is made. In addition to the state laws, Portland's city code says that employers may not exclude an applicant from consideration just because of their criminal history, and may only consider the applicant's criminal history after making a conditional offer of employment. Employers are not allowed to take adverse action based on arrests not leading to a conviction, except if the case is pending. They also may not consider convictions that have been judiciously voided or expunged, or completed diversion or deferral of judgment programs. Employers may only consider an applicant's criminal history if it is determined in good faith that a specific offense or conduct is job-related and consistent with business necessity, and that they conduct an individualized assessment. If the employer rescinds the conditional offer of employment, they're required to notify the applicant in writing of their decision and identify the specific convictions leading to their decision. In Pennsylvania, Philadelphia's ban the box law, which applies to any person, company, corporation, labor organization, or association, states that employers may not make any inquiry into, required disclosure of, or take adverse action against any person because of an arrest or criminal accusation that is not pending and did not result in a conviction. Convictions themselves may not be inquired into until after a conditional offer of employment is made. Employers also may not maintain a policy that automatically excludes any applicant or employee with a criminal conviction, and may only consider convictions from within 7 years of the date of the inquiry from the date of disposition. An individualized assessment is required, and if an employer rejects an applicant or employee based on a criminal record information, they have to notify that person in writing and include the basis for the decision. Employers must also allow the applicant or employee 10 business days to respond to the pre-adverse action letter. Now, finally, this law requires that all employers post a summary of this law in a conspicuous place on the employer's website and premises where applicants and employees will be most likely to notice and read it. Rhode Island has a law that applies to employers with 4 or more employees and states that employers may not inquire on an application or otherwise whether the applicant has ever been arrested, charged with, or convicted of any crime, and may only ask for information about an applicant's criminal convictions after the first interview. Austin, Texas's ordinance states that employers with at least 15 individuals who primarily work within the city of Austin may not publish information about a job that states or implies that an individual's criminal history automatically disqualifies them from consideration. Employers are not allowed to inquire into an individual's criminal history on an application, nor inquire into consider an individual's criminal history until after a conditional offer of employment has been extended to them. An individualized assessment has to be done before they're allowed to take any adverse action. All right, state of Vermont says that employers with 1 or more individuals performing work in the state are not allowed to request criminal history records on their initial employment application form. An employer may inquire about a prospective employee's criminal history record during the interview or once the prospective employee has been deemed otherwise qualified for the position. It also requires that the applicant be given an opportunity to explain the information and the circumstances regarding any convictions, including post-conviction rehabilitation. Virgin Islands also has a ban the box law, which doesn't allow employers to inquire into, consider, or ask an applicant to disclose information regarding an arrest or detention that did not result in a conviction, or information concerning a referral to or participation in any pretrial or post-trial diversion program, or concerning a conviction that has been judiciously dismissed or sealed. Getting to the end here, folks. All right, state of Washington prohibits public agencies, private individuals, businesses and corporations, contractors, temporary staffing agencies, training and apprenticeship programs, and job placement, referral, and employment agencies from inquiring into, obtaining, or including a question on an application about an applicant's criminal record until after the employer has deemed the applicant qualified for that position. Employers may not advertise employment openings in any way that excludes people with a criminal record from applying. And they may not implement a policy or practice that automatically or categorically excludes individuals with a criminal record from consideration prior to an initial determination that the applicant is otherwise qualified for the position. The City of Seattle's ordinance, which applies to employers with 1 or more employees, and to those employees who perform services physically within the state of Seattle at least 50% of the time, says that employers may not advertise, publicize, or implement any policy or practice that automatically or categorically excludes all individuals with any arrest or conviction record from an employment position. Employers may perform a criminal background check on a job applicant or require a job applicant to provide criminal history information after the employer has completed an initial screening of the applicant of all of the applications that they have to eliminate unqualified applicants. Employers may not take adverse action based solely on an applicant or employee's criminal history unless they have a legitimate business need. In order to determine that they have a legitimate business need, they have to conduct an individualized assessment. And then before they're able to go ahead and take that adverse action, they have to tell the applicant or employee what specific records or information they're using, and then give that applicant or employee a reasonable opportunity to explain or correct that information. And then they have to hold that position open for a minimum of 2 business days, a lot less than we're used to seeing, for them to do so. Employers must also create and distribute a poster which gives notice of these rights in both English and Spanish and any other languages that are necessary. And then finally, last but not least, the City of Spokane's law, which applies to all employers within city limits, says employers may not advertise applicable employment openings in a way that excludes people with arrest or conviction records from applying, or include a question on an application for employment. Employers may not inquire into, obtain, or include a question on an application for employment about an applicant's arrest or conviction record prior to an interview or until a conditional offer of employment is made. Employers may not disqualify an applicant from applicable employment prior to an interview just because that person has a prior arrest or conviction record, unless the conviction is related to significant duties of the job. And then they may not reject or disqualify an applicant for failure to disclose a criminal record prior to initially getting that conditional offer and otherwise being deemed qualified for the position. All right. So thanks for sticking with me through the whole thing. That's about it for the U.S. states with ban the box laws for private employers. I know it was a lot to go over, but I appreciate it.
Yeah, thank you so much. Well, Eden, I know we have a hard out with you in just a couple minutes, but we do want to get to a couple questions. First up, how long should we wait before taking adverse action if we're not in a state where it's clearly defined?
There's no really clear regulation about the specific amount of time that you need to wait if the state or city doesn't have anything specific within the regulation. But FTC, CFPB, they have always kind of provided guidance that 5 business days will generally be a safe amount of time to wait.
Okay. The candidate confirmed they don't want to dispute. Do we still need to wait 5 days before we send our final adverse action letter?
Yeah. So these laws are all consumer protection laws. So we want to do what we can to protect the consumer. And on the initial pre-adverse action letter, we generally write how long we're going to wait before we take that final action. And whatever date is on there is the amount of time that you should wait. Even if they say early, well, I have nothing to dispute. You want to wait that full amount of time.
Okay. And then last question, because again, I know we're over the time that we have with you today, but if a background is partially complete and what we have disqualifies them, can we start the adverse action notices?
You can. It is not recommended, but you can. If you know that something within the consumer report is going to be disqualifying for you, you can go ahead and take adverse action, but best practice is to wait.
Okay, and then just a real quick follow-up to that. In that same vein, if courthouse closures are really stretching background checks, because I know we've seen that happen a couple times over the last 2-3 years, is that something where you could still just start the adverse action process?
Yeah, if you don't need to wait on additional information because you have enough to make a preliminary decision, then you can go ahead and start with the adverse action. But keep in mind, you'll never know what's going to come back on those remaining searches or components.
Okay, awesome. Well, again, Eden, thank you so much for spending your time with us today and even going over it. I appreciate your expertise and knowledge today. Thank you.
Thank you so much.
Yeah, and again, thank you so much to everyone else that has attended this session and are attending these sessions. We greatly appreciate your time and appreciate you participating in Day with DISA. Hopefully we'll see you in some more sessions today, tomorrow, and maybe even in Houston at the House of Blues on Thursday. Bye-bye.